We are live. Welcome to our webinar. We're going to leave it at Vida's hand now.
Good afternoon, everyone. My name is Vida Berhusier, member of Toronto Real Estate Board and a proud member and volunteer of PICRA Association. I'd like to thank you all for joining us today for another live webinar by PICRA. Specifically for during this time of COVID-19 pandemic. I'd like to start by acknowledging the hard work that's put in by all our volunteers and members of PICRA and their amazing job and teamwork. I'd like to introduce you to our guest speaker for today, our wonderful guest speaker, Mrs. Bita Delisi. Bita is a licensed realtor and a licensed paralegal from Stonegate Legal Services. And she's here today to educate us about landlord and tenancy matters, more specifically geared towards changes due to COVID-19. By the end of our presentation, our discussion today, you will all have the chance of putting your questions into the live comments, and Bita will be answering all your questions. Without further ado, I would like to have Bita take over the floor. Hello, Bita. Welcome.
Hi, Vida. Thank you so much for having me. Thank you for having me and helping me host this presentation. Best legal practices in owning and operating rental property. This version, and just for PICRA today, we're going to talk about COVID-19, leases, and evictions. For those of you who don't know me and who don't know my firm and would like to get social with us, please head over to our Facebook and Instagram. I always I like to deliver to the masses information regarding changes in the world of landlord and tenancy, whenever the laws change regarding the board, tenancy issues, any changes, I always put it on our social media pages. So head over, follow us, and friend us. If you ever have any questions regarding landlord and tenancy matter, I'm very easy and quickly to respond. Feel free to give me a call or check out our website at stonegatelegalservices.ca. So let's get started. Perfect. I'll give you a brief introduction about myself. As Vida mentioned, my path started as a real estate broker back in 2004, 2005. And during those years, I started acquiring landlord and investor clients. And those clients, they were the bigger landlord and investor clients, not the ones that purchased, the condo unit or the house that the residential home that they want to rent out. These were investors, REITs, real estate investment trusts that wanted to purchase small to medium-sized apartment buildings and commercial plazas. But the landlords were out of town or out of province. So of course their tenants would call me for everything. So I started a property management company with my husband, Rob, and we ran that business for a little while, and we currently do today. And we manage apartment buildings, commercial plazas, and schools and churches. And through that path, I started going to the landlord and tenant board to evict tenants for non-payment of rent, damages, illegal activities, persistent late payment of rent. And usually when I would go to the board, the adjudicator or the judge deciding on the matter would often dismiss my matter because I wasn't a licensed paralegal or lawyer. So I went back to school just for my investor clients and landlords. I obtained my paralegal license, and here is my firm was born, Stonegate Legal Services, and all we do is we do landlord and tenancy matters. That's it. Because of our background in real estate, 95% of our business comes from real estate agents like yourselves. So throughout this presentation, everything we discuss is for information only, and nothing is to be taken as or construed as legal advice. If you have a matter or if you have a question that you want to talk to me about, please feel free to send me an email or give me a call. I'd be more than happy to talk to you. So let's get started. So let's talk about how COVID-19 has affected the realm of tenancies. So my office has been flooded with calls regarding, landlords and investors and realtors wanting to know what the statistics are on how many tenants paid rent and how many didn't. So let's talk about how many tenants actually paid rent during COVID-19. And this is going to go back to the month of April. So media sources state that 85% of Canadian tenants in all of Ontario paid the April rent. Okay, this is fantastic. This is a high amount. 60% paid for May, and the June statistics have not come out yet, or not released yet. Now, although 85% may seem like such a high amount, in percentage, the remaining 15%, if you were to calculate how many homes or how many rental units did not pay, this totals out to be 75,000 households or rental units or landlords did not receive rent for the month of April alone. And those numbers are much higher for the month of May, and we are predicting June and July will be much higher than that. The percentage of tenants who pay rent will decline as more and more tenants end up in delinquency due to the pandemic. Now, their delinquency could be linked to a temporary job loss, temporary delay, or a permanent job loss for that matter. Commercial tenants are not protected under the Residential Tenancies Act. So commercial tenancies are they're separate beasts. They're not protected. Now, I know that many of you are realtors, active realtors. And again, because our business is focused or geared towards realtors, again, another question I always get asked is, what can we advertise? If we're advertising a property for lease for one of our landlord clients, what can we ask a tenant to provide? Okay, so here we go. What can realtors ask prospective tenants for when advertising a property for lease? So these are the 8 things that you can ask. You can ask, what is the income? If you work or where you work, how many people will be occupying the rental unit? If there are any pets. This is a really important question. If you're going to ask about pets, this is the time to ask, because once the tenant moves in, and even if they say they're not going to be bringing a pet, and then you discover a pet, there's nothing really that a landlord can do to evict and terminate tenancy because of that pet. So the time to ask about the pets is before you make that decision in the beginning. You can also ask if the tenant or prospective tenant is a smoker or non-smoker, permission for a credit check, references. Now, the references, you should be really careful, because not only you should ask for references from their previous landlord, but you should ask for a reference from their previous landlord. And the reason for that is because if they're in delinquency with their existing landlord, or they don't like their existing landlord, or they don't have a really good relationship with the existing landlord, that landlord will say whatever under the stars to get them out. So what you want is, you want to make sure not only you have a reference from their landlord, but their previous landlord. An Equifax credit report is great, because your credit report, it actually shows your ability to make your monthly payments. So you should not only pay attention to that score, you should have a look at the entire report just to see their activity. Here are things. Now, we talked about what realtors can ask for. Let's talk about what realtors cannot ask for when advertising a property for lease on MLS. So number 1, if they are pregnant or if they have children. Number 2, if they plan on having children or if they plan on having more children. These are violations of their human rights. Okay, so let's keep going. Number 3, if you're married, single, divorced, what's your marital status? What is their religion or ethnic background? What is their sexual orientation? If they are on welfare, Ontario Works, Odsp, or any other public assistance. If they have a disability, what is their age? If they're a Canadian citizen. This is the top 9 things that a realtor or landlord cannot ask for. And the reason for that is because if a realtor asks for any of these questions, or if they won't rent to a prospective tenant because of the answers, this could be grounds for discrimination and a violation under the human rights. Not only will the sales representative be held accountable, but your brokerage will be held accountable. So you want to make sure that you're really careful when you're putting together a lease. I know that we all take leases as a favor to our clients. I've done it in the past. Again, my background is in real estate, so I know how the realtors function. We take leases on as a favor to our clients. However, often the leases end up being double or triple the amount of work, and often it's not worth the commission. So just be careful when you're doing your leases. Okay, so let's talk about what not to include on an MLS listing in the comments or the broker's remarks. These are the top few things. Let's talk about utilities. So number 1, I often see agents put in their MLS listing, only for the basement, tenant must pay 40% of the utilities. The legal sharing of utilities is either based on per square footage or a split of 2/3 or 1/3 of the utility bill payment. It can't be a percentage. Number 2, this is what we're talking about. A credit report, employment letter, and a copy of a photo ID is required. While the credit report you can ask for, the employment letter you have to be really careful, okay? Because asking for an employment letter is illegal under the Ontario Human Rights Act, and prospects are not required to provide a piece of photo ID. The reason why the tenant doesn't have to provide you with an employment letter is because just because they're not employed doesn't mean that they can't pay the rent. Maybe they have income coming in from overseas, or if they're on social assistance, maybe their income will be able to cover the rent. Also, regarding the piece of photo ID is required when an agent is filling out the FinTrack. I get it. However, taking a photocopy of their photo ID is not allowed, and they don't have to provide you that for the purpose of you photocopying their photo ID. Okay, so let's talk about grass cutting and snow removal. This is a gray area, and I'll tell you why. Grass cutting and snow removal are the responsibility of the tenant. This is what we see in the broker's remarks. However, the municipal safety, housing, and maintenance standards state that it is the owner's responsibility to make sure that the property can be safely entered and exited. Okay, so the Residential Tenancies Act, or the RTA, does not address snow removal and grass cutting directly. It is the landlord's responsibility to make sure that the property is kept in a good state of repair, is fit to live in, and it complies with health and safety standards. So if you file an application to the Landlord and Tenant Board about snow removal or grass cutting, the member, the adjudicator, or the judge would actually decide whose responsibility it is at their discretion. Now, from my experience of going back and forth with the board over the past few years, is that they rule for the tenant. So they put this responsibility on the landlord. Okay, so here's number 4, tenants to provide post-dated checks. I've made this mistake in the past many times. The landlord cannot require the tenant to pay by way of post-dated checks, cash, direct deposit, auto withdrawals, any which way. The tenant has to be free and able to make the rent payments in any way that they feel is necessary. Number 5, tenants to provide tenants insurance before moving in. So I would say I get at least 5 to 10 calls from realtors every week surrounding tenants insurance. They say, the tenant doesn't want to provide the landlord with insurance. Well, let's talk about tenants insurance. The tenant's contents insurance is for the benefit of the tenant, and it is not a requirement to a tenancy. Okay, so in the Ontario Standard Lease, with respect to Section 11, allows for the option of insurance. However, there is no way to really enforce a tenant to obtain insurance. In the Ontario Standard Lease, it says that it gives a tenant an option. There is no way for a landlord to pursue an eviction through the Landlord and Tenant Board if the tenant does not get insurance. The insurance is for the sole benefit of the tenant. It does not, the landlord's liability insurance only protects the landlord's property. So if there's a leak, let's say, for example, if the hot water tank, if there's a pipe burst and it damages the tenant's contents, the landlord's insurance would only cover the hot water tank and fixing the property. It would not cover the tenant's contents insurance. So again, the best way to sell it to a tenant is that it is to the benefit of the tenant to obtain insurance. Let's talk about Form 400 here. So many years ago, prior to the Ontario Standard Lease kicking in as the only lease that can be used for residential properties in all of Ontario, what realtors used was Form 400. Now, there's a difference between Form 400 and the Ontario Standard Lease. Form 400 is the brokerage requirement to release commissions to a realtor. So your brokerage requires this to be handed in. This is not a lease agreement. Form 400 in actuality is an offer to lease. It's similar to the agreement of purchase and sale. Okay, so it's an offer to lease. Common practice is that Form 400 is signed first, and upon acceptance, if there are any conditions, after fulfillment of any conditions, then the Ontario Standard Lease gets signed. And this was what the Ontario Standard Lease looks like. So again, the Ontario Standard Lease is required to be attached to Form 400 for the brokers to release commission. However, this is the lease in its full entirety. This is about 13 pages, but you can also add schedules to this. So if you are putting leases together, any additional schedules that you're putting together should be attached to the Ontario Standard Lease and not Form 400. So these are the differences. So Form 400 is an offer, and it's the first step to leasing a residential property. Form 400 may be subject to conditions that need to be fulfilled, such as a condition on credit report. And Form 400, more importantly, is often signed first. The Ontario Standard Lease is a more detailed lease agreement. It's usually longer in length than Form 400, and once it's signed, it replaces Form 400. So I hope I provided clarity on the differences between an offer to lease and a Ontario Standard Lease agreement. They're two separate forms. Okay, so let's talk about the Ontario Standard Lease, because we all know what the offer to lease is, Form 400 is. Let's talk about the Ontario Standard Lease and what happens if a copy is not provided to the tenant. So the Ontario Standard Lease came into effect in April of 2018. It is the law that the landlord must give the tenant a copy of any written lease within 21 days after the tenant signs it. That's the law. The lease should not contain any terms that are inconsistent with the Act. If the lease does contain a term that is inconsistent with the Act, that term will not be enforced by the LTB, which is the Landlord and Tenant Board. So for example, if a landlord says, I put in new hardwood floors, and I don't want any pets because their nails will declaw the floor and it will cause damages. That no pets term is inconsistent with the Act. So if as a landlord you put that in and then you want to pursue an eviction, the board will not back you because that is an inconsistent term. So you want to be careful with those. So what happens if the landlord fails to provide the standard lease? If the landlord fails to provide a standard lease copy to the tenant within 30 days after the renter or the tenant has begun withholding rent, the renter does not have to repay that month's rent back. This is very important. Not a lot of realtors or landlords know about this. But if you come across the tenant who is a very savvy tenant and they know that if they ask their landlord for a copy of their lease and the landlord doesn't provide it, they can hold back 1 month's rent. The board will back them on this. However, there's a note, you have to note that the tenants cannot withhold more than 1 month's rent, and they must continue paying their rent for the term of their lease, even if the landlord never gives them a standard lease. Okay, so that's really, really important. Any copy of any legal document that is signed, all parties should receive a copy. This is no different than the agreement of purchase and sale. On the signature page, right above the commission trust agreement, where all parties acknowledge receiving a copy, same should apply to the Ontario Standard Lease. So what else should realtors provide to their clients? So realtors representing landlords must also provide new tenants with information about the rights and responsibilities of landlords and tenants, and about the role of the landlord and tenant board. The landlord must give this information to the tenant on or before the start of the tenancy. So this is actually, it's a brochure, and it's called Information for New Tenants. Now, the way I've put this PDF slideshow together, if you guys put your email in the comment section or send it to Vida, I'd be more than happy to send a copy of this PDF slideshow to Vida to distribute to you guys or to you directly. And it's got a linkable, it's got a link going back to the brochure so you can download it. So let's talk about rent deposits. Again, I've made many mistakes in the past, and I've learned from them as a realtor. So when I have my paralegal hat on, it's a totally different ballgame. So the landlord can collect a rent deposit from a new tenant on or before the start of a new tenancy. That deposit cannot be for more than 1 month's rent, and that deposit cannot be used for anything except for the last month's rent. Okay, so the only form of deposit, with the exception of a key deposit, which we'll talk about later on in the presentation, is the last month's rent deposit. That's it. If a landlord gives a notice of a rent increase to the tenant, the landlord can also ask the tenant to increase the deposit by the same amount. Okay, so we're going to talk about rent increase throughout the presentation as well. So the only thing to note here is that the only deposit a landlord can ask for is the last month's rent deposit. That's it. So let's talk about illegal deposits. So the following deposits are illegal: damage deposits, key deposits we'll come back to. That's why you see the 3 stars. Vehicle deposits, utility deposits, pet deposits, repair deposits, light bulb deposits. These are all illegal deposits. Again, any other deposit other than the last month's rent deposit is illegal. Now, the reason why I want to shed a little bit of light on the key deposit is because it's also listed in the Ontario Standard Lease that the landlord may obtain a key deposit, a refundable key deposit, only for the cost of the replacement of that key. Okay, that's very important. Not the cost to replace the lock. So whatever that key costs, that's what the landlord can charge as a deposit. Rent payment methods and receipts. Okay, so let's talk about what the landlord cannot require. So the landlord cannot require the tenant to pay by way of post-dated checks, cash, direct deposit, and auto withdrawals. Okay, so we've mentioned that. The landlord must provide a receipt for any rent payment or rent deposit or any other charge upon request by the tenant. The landlord must provide a former tenant with a receipt if that person asks for one within 12 months after the end of the tenancy. And the landlord cannot charge a fee for providing a receipt. So these are really important. When my husband and I were managing these apartment buildings during the month of January to April, because it's tax season, we would get flooded with emails, about over maybe 130 emails requesting a rent receipt. Now, if you are the smaller scale landlord and you're only issuing 1, 2, 3, 4, 5 rent receipts, that'll take you less than 5 minutes to issue. But if you're a bigger scale landlord and you're issuing 100 rent receipts or 130 rent receipts, I'm sure you can agree that that's very time consuming. However, the law protects the tenant and says that the landlord cannot charge a cost for providing a rent receipt. Let's talk about rent increases. First and foremost, I'm gonna start off before we get into these notices is that realtors cannot put the pen to paper and put these notices and serve it on behalf of their landlords. Realtors cannot serve any legal notice. And the reason for that is because, first of all, if you're putting pen to paper to serve a legal notice, you're providing a legal service and you do not have a license. You do not hold a license to provide a legal service. Secondly, and most importantly, is that once if there's any issues or any mistakes within that notice, you are risking your client's application to get dismissed from the board. Prior to COVID-19, it took about 5 months just to get a hearing date. So already, if you have a tenant that's not paying rent, it took 5 months just to get in front of the board, never mind to evict them. Now, with the board being closed, and thousands, it's going to be hundreds of thousands of applications that are already backlogged. When the board reopens, there's going to be an influx of landlords rushing to the board to file their applications. So this means that from the previous time that it took 5 months to get a hearing date, now it might take 9 months or a year. Do you want to risk an error in your client's notice that your client has to wait? The client has already waited 9 to 12 months to get a hearing date. Now their application got dismissed and they have to start all over again. You probably don't. So make sure you don't serve this on behalf of your clients. Rent increases. The rent to any residential property can be increased if at least 12 months have passed since the tenant first moved in or since the tenant's last rent increase. The landlord must provide 90 days notice of any rent increase. And the guideline is set every year by the Ontario government, and rent increases must be as per the guideline. So this year, for 2020, it's 2.2% increase. It has been the highest since 2013. So you still have time to issue those rent increases for 2020. Any rent increase over the guideline must have the landlord and tenant board approval. So here are, 3 top common questions that my office gets overwhelmed with from realtors. And it's because of the business that we're in. We deal with landlord and tenants every day. You guys deal with selling the property of the landlord, and often you get stuck dealing with a difficult tenant. So I get calls or text messages and emails asking me, these questions. Bita, can we evict a tenant to sell a property? Or Bita, the tenant isn't allowing for showings during COVID-19. Can we kick them out? Or here's another one. The landlord's lease is coming to an end. Can we give the tenant notice to move out? And the answer to all these questions is absolutely not. No. The reason for that is because tenants have what's called security of tenure. And what that means is that tenants are entitled. They're entitled to occupy the rental unit after the initial term specified in a rental agreement ends. So this means just because the lease comes to the end of its life or the end of its term doesn't mean that the tenant has to move out. It just means that tenancy relationship, it shifts from a fixed term tenancy to a month-to-month tenancy. A tenancy may only be terminated by 3 ways. Number 1, if the tenant decides to leave and gives notice, that's by way of N9. Number 2, the landlord and tenant agree to terminate tenancy. That's by way of N11. Or number 3, by way of the board order or a court order. Okay, so those are the 3 ways to terminate tenancy, not because the lease is coming to an end. Let's shift a little bit now to the N12. Okay, so the N12 deals specifically with the sale or the purchase of a property and how the new owner can take possession or the landlord can take possession. So let's, again, I'm going to emphasize these slides. Realtors cannot serve this notice. It's very, very important that a legal representative serves this notice. This is what the N12 looks like. That's the front and that's the back. So what is the N12 and when can it be served? So the N12 is a notice for the landlord or the purchaser's own use, and it can be served by the landlord or if the landlord is deciding to use them for his or her own personal use, if the landlord or the landlord's immediate family member or caregiver requires a rental unit for their own personal occupation. Okay, so if they're wanting to move in for their own personal use, and they have to have the intention to occupy it for at least 1 year. Okay, so that's a landlord can serve if the landlord wants the property for their own use. So what happens if a property is sold and the purchaser wants to use the property? So again, this form would be served not by the realtor, only by the landlord or the landlord's legal rep. The landlord has, now the condition on serving this notice is for the purchaser's own use. The landlord is if the landlord has signed an agreement of purchase and sale, and that agreement of purchase and sale must be firm. It cannot be conditional. The property must contain 3 units or less, and the purchaser's immediate family member or caregiver require the unit for their own personal use for at least 1 year. It's very, very important and imperative that the property is used for residential occupancy for at least 1 year. And the N12 cannot be issued if the landlord is a corporation or for members of the extended family, such as the brother, the sister, the aunt, or uncle. It has to be immediate family. The most important thing before you serve the N12 is the intention of good faith. Good faith is having the genuine intention to occupy the rental unit for residential purposes. It's very important and imperative that the N12 is served on good faith. And landlords should not serve the N12 to a tenant because they're experiencing problems with the tenant, or they don't like the tenant, or they want to get rid of the tenant because they want to increase the rent, and they feel that this is, the loophole in getting rid of the tenant. And I'll tell you why. The reason why is because a tenant can file a T5 application, and that's a bad faith application, against a former landlord for bad faith within 12 months of the date that they moved out. And the reason for that is because the tenant is relying on the N12 in order to make a move. So if they find out through, let's say, the MLS, through the MLS or the Realtor.ca or on Kijiji, that the landlord used this notice to get rid of them and they relisted for a higher rent amount, they can come after the landlord for after a year after they move out. So the limitation period for the use of this form in particular is a long time. You just want to make sure, again, it's served on good faith. So if a landlord is found to serve a notice on bad faith, the landlord and tenant board can order the former landlord to pay the difference between the new rent and previous rent, moving costs, if they had to take time off of work, whatever damages or costs that were out of pocket by the tenant. Again, realtors cannot serve this notice. So with any notice, if a landlord wants to terminate tenancy, the landlord must provide compensation. Okay, so for the purpose of this N12, if the landlord is using the property for themselves, 1 month's rent compensation must be given before the termination date of this form in specific. You must note that the unit offered to the tenant must be owned by the same landlord if that landlord wants to provide a comparable unit to the tenant instead of compensation. So it's one or the other. The simplest way, instead of offering a unit to the tenant, is, in my opinion, the 1 month's rent. And the compensation must be paid before termination date. You must also have supporting documents because you have to prove to the board through a declaration or an affidavit that you do have genuine intention of either moving in or the property has sold. And that way you have to provide a firm agreement of purchase and sale. Again, don't do this yourself because this is not a DIY form. Hire a legal representative to do this, definitely. So moving along, this is I took a screenshot of the back page of the N12. I want you to pay your attention to The second one coming down on your left, where it says a tenant can give 10 days notice to end tenancy. And also the one below that, what if you disagree with this notice? So let's talk about what if you disagree with this notice. It says right on here on the N12, if you disagree with this notice, you do not have to move out of the rental unit. That's what it basically says. You do not have to move out if you disagree with that, with what the landlord has put in this notice. If the tenant wishes to dispute this notice, they are not obligated to move out of the rental unit, and they can remain in the unit until they receive a hearing date. So typically when this notice is served, you serve it onto the tenant, you file it with the board immediately. The reason you file it with the board is that if the tenant becomes uncooperative, you want to make sure that the board holds a hearing and they issue you an eviction order if that tenant doesn't want to leave. This is very, very, very important. Okay, you need that eviction clause. You need that eviction order from the board. If you don't file it with the board, if you don't get an order to evict, then your closing date on your agreement of purchase and sale may need to be amended to a later date. So it throws off your closing date completely. Now, the reason why I said a tenant can give 10 days notice to end the tenancy, again, it's right on there. If the tenant decides to leave earlier than the termination date indicated on the N12, then the landlord must provide a refund of any extra rent in his or her possession, as well as to provide the 1 month's rent compensation. Okay, again, the form may get a little bit complicated. Realtors, please do not serve this notice. It is out of your scope of work. Your insurance won't protect you, and if you make a mistake, your client and your deal will suffer. Okay, so consult legal representative before you do this. So what happens if the client changes their mind? So I had a call before coming on to PICRA's presentation here by a realtor who had served the N12 on behalf of his landlord, and they've informed the tenant that the landlord is going to be moving in. However, the landlord is not going to be moving in. The landlord is going to be selling. Well, there is no set way to cancel the N12 once it is served to the tenant. Landlords must make certain that the person whom they have set in the application that there is going to be moving in is in fact 100% committed before serving the N12 to the tenant. So once it's served, it's served. You can't say, well, the person changed their mind. My daughter changed their mind. Well, if that's the case, you must notify the tenant right away with a letter explaining the change in the circumstance. You must inform them that they can disregard the N12 and continue the tenancy. However, if it's too late to cancel, for example, if the tenant moved out earlier, if the tenant signed a new lease, whatever the case is, compensation must still be paid. And if the tenant files an application for bad faith, they can sue the landlord for up to $35,000, and they will win at the board. So there's no way of reducing that amount with the board. You have to be really, really careful when you're using the N12. Another question that I get asked from realtors is, how can you serve tenants? I remember when I first started real estate, fax machines were very popular. We were faxing offers in 2004, 2005, 2006. Emails were not popular. PDF, I don't even think was invented back then. But right now, the world of the real estate realm is very advanced. However, the world of law and justice, as I like to say, the wheels of justice spin very slowly. We are still using fax machines. The whole purpose of me telling you this is that emails and text messages are not an acceptable method of service. Landlords must serve their tenants according to rules of the Landlord and Tenant Board, and they must fill out a certificate of service, which is also similar to an affidavit, and file it with their notice for a hearing. And in that notice, they must disclose to the board how they have served the tenant. So the landlord may serve their tenants in one of the following ways. handing the document to the tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through the mail slot, faxing it to the tenant's place of residence or business, courier, registered mail, or express post. Now, just a note, if you're using mail, such as registered mail, regular mail, express post, you must add 5 days to the date of termination because of the delivery of this type of service. So these are how to serve a tenant correctly as per the board. And emails, again, emails, WhatsApp, taking a picture and sending it through your phone is not an acceptable method of service. And if you do that, if you do use your phone for a service of delivery of documents, and if you do disclose this to the board, you are going to risk your application getting dismissed at the board, and you have to start the process all over again. So guys, make sure you're not doing this, or you're not doing something that you're not familiar with. Consult a legal representative. So upon answering many questions for non-payment of rent, other reasons for evictions, in addition to the rent, are the following: non-payment of rent in full, persistently late payment of rent, causing damages to the property, committing illegal activities. Now, I just want to make a note here. The operation of a short-term rental or an Airbnb by a tenant is an illegal activity. So if you're acting on behalf of the landlord and you are entered into a lease with a tenant, and then soon you find out that that tenant is operating that house or unit for Airbnb purposes and renting it out on Airbnb, that's an illegal activity, and that is grounds for termination with the board. Okay, so again, going back to the reasons for eviction: affecting the safety of others, disturbing the enjoyment of other tenants or the landlord, allowing way too many people to live in the rental unit, or not reporting income in subsidized housing, or other reasons for eviction. The landlord wants to use the property for themselves or their immediate family, and major repairs are required, which will require building permits and demolition. So as you can see, it's not just the question of getting paid your rent in full and on time that may snowball into a reason to evict. There are many other reasons for an eviction. So this is, again, I'm not selling anything. I never sell any services. This is what I've put together. It's called the Landlord Mastery. And it's a guide. It's a free downloadable guide that I've put together. And this is based on my own knowledge and experience as a realtor going back to 2004, and it helps other landlords or investors, qualify tenant prospects, what questions that they can ask, what you can request. I've actually input scripts from how I used to qualify tenants over the phone. There's a link to forms such as parking agreements, air conditioning agreements, grass cutting and snow removal. There's other agreements, like I mentioned, a notice of entry that you can cut and paste your information, how to prepare a rental property for lease. Again, you have to change your mindset. If you are in this business of renting out property, you have to run it like a business. It's not, you can't be a landlord that buys a property and rents it and then just sit back and collect. This is not the way this business works. Once you own property and you're using it for rental income, you are in the business of being a landlord, of landlording. And with being in the business of landlording, you must be able to find ways to attract good tenants. Because for every 10 good tenants, there's one that's a really, really bad apple that may cause you stress. So again, this is a guide that I use even for my own properties. I own and operate rental properties for myself, that I still go back to this guide. Again, I'd be more than happy to send this copy to Vida, and she can send it out to you guys. Or you feel free to put your email in the comments section, and I'd be more than happy to send this information to you. Okay, perfect. So this brings us to the conclusion of our presentation. Thank you again for having me on. And I just want to add on, if you already haven't done so, head over to our social media pages, Facebook and Instagram. Follow us. I tend to always update you with what's going on in the realm of tenancy. And at this time, I'd like to open the floor and send it back to Vita for questions.
Thank you so much. It was a great presentation, almost covering everything. I'm just going to go through the questions and let's see. So our first question is Mr. Hamid Reza Khorasanchian. How can a landlord rent out to a tenant whose income is based on ODSP?
I don't understand. Okay, so how can he, well, he's got to qualify the tenant. So you have to make sure that the tenant is able to cover your rent. So if your rent is $2,000 and ODSP is giving them $500, well, common sense prevails that that income cannot cover the rent. However, if there is more than one, if there are more than one or two tenants that the combined income can cover the rent, that application should be considered. Now, the law says that you cannot turn down an application because that income is ODSP or social assistance. Obviously, you have to say, well, if the rent is $2,000 and you're getting $500 from ODSP, you can't cover the rent. Sure, unfortunately, I can't approve the application. However, if that person on ODSP is not the only source of income, if they have other, like let's say, for example, 2 or 3 people coming on, and they have a combined income of $4,000 and your rent is $2,000, well, then you have to make a decision, is that if those tenants are fit to occupy your rental unit.
Okay, so our next question, Mr. PJ Talat, property is being sold. New buyer wants to lease for more and ask for vacant possession in the contract. Lease is expired. If tenant is not cooperating, what can the landlord do?
So again, just because the lease comes to the end of its term doesn't mean that that tenant has to leave. And the landlord cannot terminate tenancy for the purpose of renting it to somebody else for a higher amount. You can't do that. The law won't protect the landlord.
Okay. Again, Mr. Hamid Reza Khorasanchian, if a landlord and tenant agrees to use Form 400 as a lease form, is it mandatory to sign Ontario Lease Agreement form?
It's not mandatory to sign the Ontario Standard Lease Agreement form. Your broker, if this is a lease that you're brokering through your office, your brokerage will require that to release commissions. Now, it's not even mandatory that a lease agreement be in existence. The lease agreement is, how do I say, it's the rules of the game. It's an understanding between the landlord and tenant. Who's responsible for what? Who will be residing in the rental unit? What is the amount? When does the lease expire? What are other terms and conditions? Right? Now, the law that governs the realm of tenancy, which is the Residential Tenancies Act, that is the governing law that will prevail when a matter comes in front of the board.
Mm-hmm. I'm not so sure what the next question, Mr. Ali Baluchi, what about the replacing the fobs and remotes? I'm not sure if this question was in the middle of your presentation. They're referring to some part? Or?
I think what Ali is referring to is the key deposits. And if I'm in sync with you, Ali, I think what you're asking is, can a landlord who owns a condo unit ask for a deposit, a key deposit, to cover the cost of repair or the cost of replacement for fobs and the garage remote? And the answer to that is no. The only key deposit that the landlord can ask for is the actual key for the front door of the rental unit.
Mm-hmm. Our next question is, can landlords serve an eviction notice during COVID-19?
Yes. So a landlord can still fill out and serve a notice to terminate tenancy for, let's say, non-payment of rent. I'm just going to use this example. Serve it to the tenant because the tenant is still not paying the rent, okay? The landlord has the right to file that notice with the board for a hearing. However, where the landlord is going to hit a rock is that the board is closed right now. So they won't be holding any in-person hearings with any notice with respect to an eviction. And the notice for non-payment of rent is a notice that has an eviction. So therefore, you will have to wait for the board to reopen in order for you to get a hearing date. However, the benefit to serving the notice now than waiting for the board to reopen is that at least your notice is with the board and in queue. And all you're waiting is to get assigned a hearing date. So the answer to that question is yes, the landlord can still serve notices to terminate tenancy.
Beautiful. Mr. Al-Sadeghi asking if the buyer is acting in bad faith and don't use the property other than his own use, does the seller in any case in fault after the deal is finalized?
So in your agreement of purchase and sale, where the completion date clause is, it's built in there that the seller is to provide the buyer with vacant possession by 6 p.m. on such and such date when the property closes. However, a lot of agents put in Schedule A, or they do a Schedule B, saying that they will provide the vacant possession for the purchaser's own use. That is recommended. You want to make sure that it's very clear that the seller will provide vacant possession based on the instructions of the new purchaser. However, if that tenant finds out that notice, they were served on bad faith, and they can consult a legal representative, that legal representative will hold the seller accountable. So you have to make sure that the paperwork is done correctly, not only to cover yourselves as a realtor, but to cover your clients. Because again, if a tenant brings a bad faith application forward, they can sue at the board for up to $35,000.
Mm-hmm. Next question, can a tenant refuse to pay rent increase that landlord applies every year at rate of Ontario rate increase?
So no, as long as that rent increase, the N1 rent increase form is filled out and served correctly, that the tenant has no choice, but they have to pay the rent increase.
Mm-hmm. What kind of right does a tenant have when the property he or she lives in gets sold to another party? Can tenant give notice and leave, or has to stay for full term of their contract?
So if they have a lease in effect, then the lease should be honored by the new purchaser. However, what that means is that new purchaser has assumed that tenant. So in order for the purchaser to get vacant possession for their own occupancy is when they have a firm agreement of purchase and sale. However, if that tenant is still in a lease agreement with that landlord, that new purchaser has to honor that lease agreement.
Our next question, Mr. Ali Bulerchi. When delivering notices to the tenant, there is an email option, but if you send it by email, then in a court, they will not accept the notices delivered. Why? Are we still living in 90s?
It's because the world of the law world is very, very slow. I do understand, Ali, that in the Ontario Standard Lease Agreement, there is an option of communication or delivery of notices via email. The board has developed a new notice with respect to email delivery of notices via email. However, again, with my experience in dealing with adjudicators, even with that notice signed by both parties, the application does get dismissed often. So again, I'm going to say, even with that, it is a 50-50 chance. You probably don't want to risk that, do you?
Okay, Mrs. Simin Isabeklu. After a week of tenancy started, the tenant decided to terminate his tenancy. How many months rent the landlord eligible to collect from the tenant?
Oh boy. Okay. So if the tenant has a 1-year lease agreement, the landlord can pursue to collect or try to enforce the lease. However, again, with my experience, it's not a very strong case for the landlord to pursue and win. And I'll tell you why. Is that if the tenant gives you a letter or a legal notice to terminate tenancy, they have to provide you with 60 days notice. So the landlord will automatically have their first month and their last month. And by the time they leave, I'm assuming it'll be 2 months, right? The issue with that is that the landlord must mitigate or lessen their damages. So in order for the landlord to go after any damages or losses, the landlord must, again, reduce their damages by re-renting the property as soon as they can so they don't lose X amount of money. And if they do decide, if the property doesn't end up renting out, and if they do decide or they want to go after the tenant because they've lost thousands, they can try to pursue it in the small claims court. However, again, from my experience, because tenants are not very informed with the law, it's a very difficult case to win in the small claims court. My best advice regarding that is get it on the, first of all, obtain the services of a realtor, because realtors are pros at finding great prospects. So obtain the services of a realtor, get that property listed on MLS.ca, listed properly in accordance to what market value should rent out for, and get a better tenant. Okay, and our landlord mastery guide actually helps you attract better tenants.
Next question, Mr. Ali Belurci. How long a landlord should wait, or what he should do of the tenant if the tenant refuses to pay rent?
If the tenant refuses to pay rent, or if the tenant doesn't pay rent on the day that the rent is due, the landlord should serve a notice the day after. I always recommend you have to move on these. Don't sit on it for 1 month, 2 months, 3 months, 4 months, because that is like a snowball effect, and the board is already backed up and they're short-staffed and backlogged. Once the board opens, there's going to be an influx of landlords rushing to try and get a hearing date. So it's very imperative that the landlord moves on this the day after the rent is due.
Next question, what is different between subletting and assigning a unit?
Oh, wow. Okay, so this is a whole different presentation. Maybe Vita will have me back for subletting and assignments. Subletting, I'm just going to list a few points, because we can talk about subletting and assignments for hours. Assignments is having another tenant step into your shoes and take over your contract. Okay, that's assignments. Similar to when you're buying an assignment for your client, for your buyer. You're buying a contract. Okay, so that new tenant is stepping in the shoes of the existing tenant. So subletting, you must take in a few factors for subletting to be considered a legal sublet. And some of these factors are, number one, that original tenant must be within their 1-year lease. And the reason for that is because that lease has an end date. If it did not have an end date, it would be an illegal sublet, because any contract after the 1-year lease is an indefinite term, and it cannot be an indefinite term. So for a sublet to be considered legal, first of all, that original tenant must be in their 1-year lease. They must be moving out of the rental unit in order for the new tenant to be moving in, and they must move back into the rental unit for that tenant who's subletting, that it must move out within that 1-year lease. So again, 3 factors. They must be within their 1-year lease. A move must occur, moving in and out within that 1-year lease, for it to be known as a legal sublet. So again, I'd be more than happy to come back because subletting in itself, an assignment, is a whole separate presentation. We can talk about that for
Great.
hours.
We would like to have you back. Next question, Mrs. Chervin-Zonalian. A landlord must sell their unit due to the effect of COVID-19 to their financial situation. The tenant has 5 more months to the end of the term. What are the rights of each party in this case?
Okay, so again, we talked about the rights of the tenant. The tenant does not have to move out because the landlord wants to move, because the landlord wants to sell the property. That's the right of the tenant. Until the landlord obtains a firm agreement of purchase and sale and then provides legal notice to the tenant does not have to move. However, the tenant must be cooperative and allow for showings. However, here we go, another however. In addition to what's going on with COVID-19, a lot of tenants are not cooperating or they're refusing showings because they don't want people walking into their property. What I'm advising realtors to do is to talk to that tenant. You need the cooperation of that tenant in order for you to sell that property. I would advise the tenant that anyone walking into the property will be doing so taking safety measures. I've recommended that listing agents put together emergency showing kits. And what that is that's a kit that you can put at the front door that has gloves, masks, booties for their shoes. You have to give them specific instructions not to touch anything or open anything. You have to make sure that tenant is cooperative, because if that tenant doesn't feel safe, they won't allow for showings. And if they don't allow for showings, due to whatever reason, COVID-19, financial losses, nobody's coming into that property for viewings.
Yeah, so kind of related to our next question, Mr. Arash B. If a tenant gives notice to leave 60 days prior to the end of their contract but refuses to give access for showing, what are the options for the landlord?
Again, when the property is tenanted, that tenant controls the property. That's why cooperation from the tenant is really, really important. If the tenant refuses, then the landlord can pursue a notice for interference and pursue an eviction through the board. Again, however, if the tenant gave you 60 days notice and it takes 3 months, 5 months, 9 months to get a hearing at the board, you got to make a decision if it's worth it to go through the board to pursue an eviction, or if we should just wait until the tenant leaves and then show the property.
Mm-hmm. Our next question, Mrs. Sirin Isabiklu, is it illegal the landlord asks the tenant to declare in writing if they lost their job?
Yes, the tenant is not, they don't have to provide the landlord with these personal information. It's actually no business of the landlord if the tenant lost their job.
Mm-hmm. Our next question, so if the property is sold and the buyer delivers a notice to vacate at the end of the lease agreement, can the tenant move sooner?
So the buyer would not deliver that notice. The seller would deliver that notice saying that the property is sold and that the new purchaser is moving in. And what was the second part of the question, Vita?
If the property is sold and the buyer delivers a notice to vacate at the end of the lease agreement, can the tenant move sooner?
The tenant can move sooner, provided that the landlord will allow for them to move sooner without penalty.
Mm-hmm. Our next question.
It'll even be better for the tenant to move sooner, right? At least the tenant is gone.
Mm-hmm. Mrs. Paris Durashadi, the property is sold, the tenant is in the middle of contract. Can the new landlord ask for credit reports or references named from the previous owner of the tenant?
No, unfortunately not. The tenant is not liable to provide that information, and neither is the previous landlord. Once a property is tenanted, if the new purchaser agrees to assume that tenant, then they've assumed that tenant. What does it matter if they want their paperwork? Their paperwork is at that point.
Next question, can landlords serve an eviction notice during COVID-19?
Yes, I believe we answered that, and the answer is yes.
Covered this one. If realtors want to manage properties for their clients, do they need any kind of insurance? How can they obtain it?
You would have to contact your insurance company or an insurance broker for information on that. For our property management company, because we manage apartment buildings, commercial plazas, schools, and churches, it's on a bigger management scale. We have liability insurance for our own purpose because your errors and omissions insurance as a realtor will not cover property management activities.
Okay. I think we came to the end of our questions, unless if anybody has any more questions they'd like to add in. We're gonna go once, twice.
Excellent. Well, Vida, I'd be more than happy to send this presentation through PDF version to your email if you'd like, or if you want to send it to the members at PICRA, they can hang on to it, or they can download. There's the clickable downloads that I've included as well.
For sure. Vita, thank you so much for joining us today. It was a great session, very informative. I'd like to thank you on behalf of myself, PICRA, and everybody that joined us today. And I'd like to invite all our colleagues, please feel free to contact Vita with any of your questions. Her information is attached to this webinar, and her contact information. And at the same time, I'd like to invite everyone to our next live webinar, which takes place on July 19, which is a Friday as well at 3 p.m. Our next guest speaker is Mr. Stephen Moranis. Mr. Moranis is a real estate strategist and columnist and is the former president of Real Estate Board. I also would like to thank Canada Create Technical Support for managing this webinar today. They did a great job bringing it all together. Thank you, everyone, for joining. Please stay safe, everyone. Don't forget about the physical distancing. We can all together help and reduce the spread of this virus. Have a great Friday. Thank you again, Vita. And we're looking forward to see everyone on our next webinar. Have a good day.